Hi, and welcome to Hull and Hull TV. I'm Dana O'Brien, and I'm joined by Ian Hull and Suzana Popovic-Montag, partners at Hull and Hull LLP, an innovative law firm with offices in Toronto and Oakville that practice exclusively in estate, trust, and capacity litigation. Here at Hull and Hull TV, we're exploring the issues around estate planning that affect you. Ian and Suzana, even with a well-thought-out will, it can be challenged in court by families. So help guide us through some of the logical steps in avoiding litigation and keeping everyone on speaking terms. Suzana, let's start with you. What are some of the challenges presented by an extended family, for example?
Well, in situations where you have perhaps an ex-wife, stepchildren, a common law partner, there may already be some tensions that are sort of running underneath the family dynamic there that may make it difficult to have these kinds of discussions because of a fear that perhaps you may exacerbate the situation. The reality is, though, that these are the very situations in which communication is really more important than almost any other. And so having discussions and these communications will really facilitate the estate plan and ultimately being upheld. And that's also the reason, I think, where you would consider having things like a separation agreement or a marriage contract or a cohabitation agreement as part of your global estate plan. Because at the end of the day, you really do want to make sure that all of your I's are dotted and your T's are crossed.
You mentioned family dynamics. Family dynamics are changing, aren't they, Ian? And that opens up all kinds of complications and potential litigation, doesn't it?
Well, it really does. And our culture in Canada now has changed, and it is going to continue to change. The family unit is looked upon in different ways, and an estate plan needs to adapt to that. We also have to accept the fact that every family has their own issues and their own dynamics and their own tensions. To what extent they will affect the estate plan is different in each case. I never want to forget and push my clients to really consider what are the hot button family dynamic issues when they're trying to create their estate plan. And then there's always the spicy issues. We've got situations where there might be extramarital affairs, or there might be children that were born out of wedlock. And to the extent that they can be attended to or considered, directly or indirectly, that's going to go a long way to resolving problems at the end of the day.
Suzana, what happens if a will is not well drafted and someone scribbles some notes on a napkin to update a will, for example? Is that something that happens very often?
Actually, unfortunately, it is quite common and in many cases a huge source of estate litigation. It really comes back down to the old adage that you get what you pay for. And if you're going to perhaps cut corners in order to avoid having to pay, top dollars for a very strong will done by someone very reputable, you may find that there are consequences to that choice, and there may be some problems with the will that's ultimately drafted. It may be unclear. It may have ambiguities that just make it very difficult to deal with that. If you're making changes to a will that's already been done yourself, again without the benefit of legal advice or a lawyer involved in the process, then you may have unintended consequences to that as well.
Ian, what's another common reason why wills are challenged?
Well, I think it's, again, ties into the complexity of our worlds today, and that is our asset mixes. We might have assets in an RSP over here, we might have an investment account over there, we might have a holding company to avoid some of the death taxes that can exist, we might have inter vivos trusts. All of those complicated mixes of assets can bring out the worst of an estate plan and an estate administration if you haven't addressed every single one of them. So I will constantly remind my clients, for example, let's really make sure we've got the designations on the RSPs done. Let's make sure that the insurance company or the investment advisor that holds that asset has it in their file. Double check those kinds of details. It's not just signing the will document, it's addressing your asset mix that is going to flow in your estate and is going to flow outside of your estate that can really help avoid the problems.
And how important is choosing the right executor in avoiding family friction? Suzana?
Well, in my opinion, I think it's crucial. The role is so important, and you want to make sure that you understand the rights, the responsibilities of an executor. Many times people don't even realize that an executor doesn't have to be a family member. It can be perhaps a family friend, another professional, or even a trust company. And because the rule is so important, you want to make sure that you're choosing someone who's going to be fair to your beneficiaries, who doesn't have any preconceived notions of how your estate ought to be administered, notwithstanding your intentions, and someone that you ultimately trust implicitly.
So make sure your will is in order and talk to your family about it. Ian and Suzana, thank you. And thanks for joining us on Hull TV.